This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why, if there's no claim, there's no coverage, and a search warrant issued against a person insured is not a claim. In Brown Goldstein Levy LLP Joshua Treem versus Federal Insurance Company, a May 18, 2023 decision of the Fourth Circuit Court of Appeals, the law firm BGL and one of its partners, Joshua Treem, sued their insurer, Federal Insurance Company, when it refused to provide coverage for costs the appellants incurred after the government investigated Treem, executed a search warrant at BGL's office, and notified Treem that his representation of certain clients may present a conflict of interest. The district court dismissed the appellant's complaint, holding that there was no claim, as that term is defined in the insurance policy, and alternatively, that any costs appellants incurred were excluded from the policy's definition of loss. The government began investigating attorney Kenneth Ravenel in connection with a federal racketeering investigation. Ravenel engaged Treem and the firm to represent him in the investigation. The government sent Treem a letter informing him that he was now subject of the investigation and his conduct was within the scope of the grand jury's investigation. On June 13, 2019, the government obtained a search warrant and seizure warrant for BGL's offices, which it executed on June 18, 2019. In executing the warrant, the government seized tens of thousands of documents, including all of Treem's emails, regardless of their relationship to Ravenel or relevance to the ongoing investigation. That same day, the government sent Treem's counsel a target letter, to advise that Treem was a target of the ongoing criminal investigation, and the grand jury had substantial evidence linking Mr. Treem to the commission of crimes. Appellants sought relief in the district court, arguing that the seizure was beyond the scope of the investigation into Treem and Ravenel, and further objected to the government's use of a filter team to inspect the documents seized for attorney-client privilege. Appellants moved for a temporary restraining order and a preliminary injunction, and they prevailed at the Fourth Circuit in re search warrant, a decision of the Fourth Circuit in 2019. The appellants maintain that they incurred over $230,000 in defense costs related to the search warrant litigation. Appellants obtained a professional liability insurance policy from Federal, covering claims between November 21, 2018 and November 21, 2019. The policy defines a claim as any of the following: A written demand or written request for monetary damages or non-monetary relief. B, a written demand for arbitration. C, a civil proceeding commenced by the service of a complaint or similar pleading. Or D, a formal civil, administrative, civil, regulatory proceeding, including a disciplinary or grievance proceeding before a court or bar association, commenced by filing of a notice of charges or similar document, or by the entry of a formal order of investigation or similar document against an insured for a wrongful act, including any appeal therefor. Appellants, the lawyers, gave notice to the insurer of their intent to seek insurance coverage pursuant to the policy for the losses incurred in the search warrant litigation and the defense costs associated with defending Treem in connection with the criminal investigation, the partner claim. Federal sued, asking the court to declare the parties' rights and obligations pursuant to the policy and seeking damages for breach of contract. The district court issued an order granting appellee's motion to dismiss, and in doing so, the district court held that the search warrant claim was not entitled to coverage pursuant to the policy because it did not fall within the policy's definition of a claim. And even if it did, the costs associated with the search warrant litigation do not constitute defense costs under the policy. Now, in analyzing the issue, the Fourth Circuit noted that Maryland courts, they were required to follow, only construe policies of insurance against the insurer when a policy term is ambiguous. A policy term is considered ambiguous if, to a reasonably prudent person, the term is susceptible to more than one meaning. If no ambiguity in the terms of the insurance contract exists, a court has no alternative but to enforce those terms. Concluding that the government did not seek to redress any diminution of its legal rights, nor did it seek a remedy for any harm brought upon it by the appellants, the warrant application was not a demand or request for relief against the insured. The search warrant itself is not a claim, because it is not a written demand or request. Neither the search warrant application nor the resulting search warrant are written demands or written requests for non-monetary relief against an insured as required by the policy. Therefore, the search warrant claim fails because the appellants cannot state a claim for relief. The conflict letters are not claims. Despite appellants' attempts to characterize them as demands, they are not. In my opinion, lawyers' liability insurance covers many actions against the insured lawyers, but the policies do not cover every possible cause of action or problem faced by a lawyer. The conduct of the government against Brown, Goldstein, Levy, LLP, and Joshua Treem were egregious and resulted in the Fourth Circuit issuing a restraining order against the government. However, what the government did was not a claim, nor were the actions of the insured against the government defense costs. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, where you can subscribe to the blog posting and be advised of all posts, usually 5, sometimes 6 a week. And you can also subscribe to the videos on YouTube and on Rumble. And if you do, I'd appreciate it if you click on the like button or the thumbs up button on Rumble. And if you found this video and or the blog posting to be useful or interesting to you, please tell your friends and colleagues so that they can also subscribe. And if you would like to have additional information, additional detailed work on insurance and insurance coverage and insurance claims, please consider subscribing for a very small fee to my Locals channel and to my Substack publications. Thank you for your attention.